It's another beautiful Sunday afternoon. This is Rubbin Minds. Welcome. My name is Ebuka Obiuchendo. Yes, we are still in political season, a few weeks to the general elections on the 16th of February, where we shall be electing federal legislatures and, of course, the president. We had planned to have a vice president who is also the running mate of the APC candidate, President Buhari, on the show today. But unfortunately, we can't have him on the show today. A few circumstances came up beyond our control, and he had to cancel. And we'll probably reschedule in the future and keep you posted on that. But that aside, of course, the show must go on, and we're going to be talking today about the topic of the day. On Friday, Mr. President did put out a statement and gave a broadcast talking about the suspension of the Chief Justice of Nigeria and appointed an acting Chief Justice in his place. And a lot of conversation has come up out of that, and we're going to be trying to dissect that and see where Nigeria is headed from there. I have here with me Felix Ologbonyo. Thanks for being here today.
Good afternoon.
And Andy Obuoforibo. Thanks for coming.
Good afternoon, Ebuka.
So straight to the point. I mean, you're a lawyer. Just give us your perspective, first of all, on the constitutionality of the president's move.
Suspending the CJN.
Yes.
That seems to be a big question, but I think where we should start from, just a whole lot of things, but basically, the Constitution recognizes the executive, the legislation, and of course, the judiciary headed by the CJN as independent of each other, of one another. And of course, the Constitution clearly provides the step to be taken in removing any of them. For the president, you talk about impeachment, aside from other provisions of the Constitutions, those relating to his capacity to continue to act in the position of the president. For the Senate, the Senate president can be removed by the members. And of course, the Constitution clearly states how the CJN and head of other courts in Nigeria can be removed. For the CJN, if the allegation of course leveled against the CJN is investigated, and of course such is supposed to be investigated by the NJC, the National Judicial Council. And after such investigation, if the president is found culpable, then of course, it's still, I mean, if the CJN is found culpable, of course, it's still the citizen of this country. The fact that the CJN does not make him to be above the law, then the issue relating to leveling a charge against him at the CCT can then come to the fore. And if he's found guilty by the court, of course, he should have his time in court and, of course, face the consequence of his action. What we are saying is, my viewpoint is not that the CJN is above the law. No, that cannot be. But if the CJN must be removed, the president has to follow what the law provides in relation to the removal of the CJN. You
hear all that, but there's an argument that people have been making, talking about the fact that this is not the removal, that what we have is a suspension, and there's no provision for that in the Constitution. So there seems to be a loophole which the president may have decided to latch onto. What's your take on that?
It's fairly simple. Like the barrister said, you have three arms of government. They are separate and they are equal. We tend to believe in this country that the president is, we say is the highest office in the land, but it's really not. The presidency, the Chief Justice of the the office of the Chief Justice, and the office of Senate President are equal, because each of them are heading a different department of government, a different branch of government. One HOD cannot suspend another HOD in your office. They are all separate and equal. The only time one branch of government can act against another branch is in a way specified by the Constitution. The president cannot take on more powers over the CJN than what the Constitution has given him. And the Constitution is very clear. There are two ways to remove a CJN. The NJC recommends it and the president acts on it, or the other two branches of government, the president and the Senate, come together to remove him with 2/3. It's very simple. You cannot decide as a president that because you don't like what the CJN is doing, or because you believe what the CJN is doing is illegal, that you will trample on the Constitution and go after him in a way that is illegal. If you feel the CJN is acting in a way that is above the law, you yourself cannot go above the law to remove him. It's not right.
So what should have been the way out of this now, before we even get to the part of a new one acting CJN being sworn in and the constitutionality of that? What should have been done in this case now? Like we said, it's gone to court. There's a CCT pronouncement on this issue, which the president says is acted on. Should the president have kept quiet? Should the CJN not have convened the NJC? What should have been done in the situation that we were in?
Well, there are a whole lot of convoluted issues here. When you look at all that has happened, let me not just start by even talking about the process to be followed by the president to suspend, but I overhear you saying what the president said is suspension and not removal.
Removal, yes.
Then in this circumstance, I don't want us to look at what the difference between removal and suspension, what could be the difference, but what actually is the implication? Are you suggesting that it is possible for the head CJN, you can, if I discover that we are referring to him as an head CJN, to be reinstated by the president again? So you only have the same...
But if he's suspended, is that not a possibility?
You have the same implication, but let's see how the whole drama unfolds. But what I'm saying is, let's even forget about the issue of the president following the initial step that ought to be taken whenever a charge is leveled against the CJN to ensure that the CJN is actually removed from the office legally. Now, let's just start from the fact that this matter is or was in court, as at the time the CJN was purportedly suspended and is still in court as we talk. In fact, I think the motion challenging the jurisdiction of the CCT to actually air this case is coming up tomorrow for hearing. I don't know if that has not become an academic exercise by now. Now, let's even forget about the fact that NJC was not even carried along as stated by the Constitution in ensuring that the CJN is actually tried and, of course, investigated to ensure whether he actually committed the offense or not. Now, let's continue from the fact that this case was already in court and is still in court. The Court of Appeal has given an order, yes, restraining the CCT from continuing with the matter. Then the CCT has actually fixed a date for the hearing of the motion challenging its own jurisdiction. You don't need to go to law school to understand that once the jurisdiction of a court is challenged, what needs to be settled first is the issue of jurisdiction. Then the court is actually not allowed to proceed or take any further step in such case. And in fact, what has actually happened now is that the court has actually gone further to take a step which, of course, has made the whole issue of jurisdiction or no jurisdiction to become a moot exercise. Tomorrow, I wouldn't know, maybe the lawyers to the CJN or SCJN will be in court to argue the motion or to listen to the ruling of the court. I wouldn't know the effect that will have on the present issue that we are discussing. Then again, when you look at the purported motion or the ruling that was given by the chairman of the tribunal, by the CCT, if you read through the ex parte motion, first, they came by way of ex parte. And when we say ex parte in law, it means that the other party was not put on notice. In this instance, the CJN or the lawyers representing him were not put on notice of the fact that a motion was being filed and, of course, being moved in court, stating that the CJN had to step aside. And the court went ahead to give a ruling on such motion, which is going to have a fundamental and sweeping effect on the proceeding before the court. Then again, if you look at the face of the motion, you will discover that the motion actually bears no name of legal practitioner. And that leaves us in doubt to begin to think, which lawyer actually moved this motion before the court? Was it the court, was it the CCT that actually came up with motion so motu and decided to rule on it and ordered that the CJN be step aside to ensure that investigation goes on? A whole lot of issues are involved.